She's my go-to settlement company. So we're just going to start off and let her just kind of introduce herself and tell us a little bit about herself.
All right. So I'm Becky Offit with Elite Closings. Sorry, it's kind of strange because there's like live people.
I know.
And there's a camera, so I'm like not quite sure where to look.
That's okay.
So just bear with me there with my weird looking. But I have been in the real estate industry for about 10 years. Little background on me, Elite Closings is actually owned by my mother. So I joined her almost a little over 10 years ago now. My anniversary date was early July of 2012. And I've been working with her since, but I've kind of been around real estate my whole career, my whole life, really. So yeah, 10 years in the business. I'm a licensed title insurance agent. I'm also a licensed notary public. I do a lot of the closings, business development, and kind of the jack of all trades. So I run the office as well. So if you have a question, I'm your girl.
Awesome. I can say this too. When she says that, she means it. So if you've got a situation with how title's coming back or whatever, even if you're on the seller side and you haven't selected the closing company, if you've got a question and you want good answers and smart answers, she's definitely the person to call. Okay, so tell us a little bit, just a brief synopsis of the settlement process, like contract to close, what that looks like for you guys.
All right, so contract to close. So we're presuming you're already under contract. So you already met your buyers, you got them pre-approved, you wrote a contract, it's been executed by all parties. Presumably you've also negotiated a lot of that with exception of the buyer's reply to inspections, that kind of thing. So what you do at that point is you send me the contract for the sale. You also send me your lender's contact information. What we do with that is we open a new file in our system. We then order the title search itself along with the municipal exhibits. Some people call them municipal exhibits, some people call them lien letters and tax certifications. They're all kind of the same thing. In Pennsylvania, there is a 3-year time period for municipalities and tax collectors to file liens for taxes and municipal claims. So in that interim period, we have to actually order the certifications from the tax collector and the municipality because they haven't filed them as liens yet. So there would be no other way to find them other than to send out these letters. And they're literal paper letters. We mail in the mail. They mail them back to us with what's due and payable that hasn't been reduced to lien or judgment yet. Once we're gathering all of that information, we're also sending you information as well. So if you're the buyer's agent, we'll send you out an information form for you to fill out. And technically if you're the buyer to fill out, it'll have their contact information. We need their dates of birth, social security numbers, where they're banking, so we can help them with that. And we'll talk about that too. A lot of people that are moving from out of state don't bank at an in-state bank. And that can cause them some hiccups during closing because they can't get a cashier's check because the bank requires personal appearance, or they need to send a wire transfer. And the wire transfers also generally require personal appearance, or certain banks have a cutoff amount that you can't wire without being in person. So it's kind of hard.
It should probably be at the top, like everything else.
Can you mute, please? Who's that?
I think that was
Lisa. Thank you. Go ahead.
Thanks. So we'll ask for the buyer's information. We also send out information to the listing agent asking for similar items from the seller. We gather their payoff information, and we work on all of that. As far as things that we need from you to get to settlement, we'll put that in the email as well, but it'll touch on whether there's occupancy inspections required, die tests required, anything kind of out of the ordinary that the municipality requires in order for the property to be sold. All of that information gets gathered. We then work on 2 different types of clear to close. So you've heard clear to close from your lenders most likely. There's also clear from the title side. So your lender gets their clear to close generally after we do. So title is part of the need for the lender to be cleared. So we're guaranteeing, we're ensuring that there's no issues on the property that will cause a financial loss to either the lender or the purchaser after closing due to something that happened in the past. So that's kind of what we're working on while you're doing all of your other stuff. So you're doing all your buyer's due diligence, they're applying officially for that mortgage, they're clearing all of their conditions, doing inspections, all of that happy stuff. Then we get the lender's instructions to prepare the settlement statements. We match those with the lender, send them out, and get you scheduled to go to closing. The general time period for that these days is still the 30 to 45 days as a general. Some take longer, some can go faster, but that's basically the process from start to finish. So we're the people that handle the legal part and the money part of the transaction. So we get everything going in conjunction with the lender. But title, basically, just for your own knowledge, we work mostly in the background. So if you don't hear from title a lot, that's a good thing. You don't want to talk to us all that much, unless you do. I mean, we're happy to talk to you. You can call us and let us know. But if you don't hear much from us throughout the process, that generally means you're in good shape.
Okay, sounds good. All right, so getting into the meat, this is my favorite part of it. When you get the order, well, you already said, like, what are the main things needed? You said, and I know from my experience, anything that is an addenda to the agreement of sale, you want to make sure that you're sending to settlement also. So if you have an oil, gas, mineral addendum, not the disclosure, but if you have it checked on the contract that that's included, make sure that you send that to them, as well as any other addendum that might be applicable to the contract that's mentioned on the agreement of sale. Down the road, after, like, say, inspections or something, if the price changes or whatever, you're going to make sure that they're getting that as well. Okay, so tell us, what are the main mistakes that agents make when opening a file with you?
Sure. So some of the main mistakes that we see are, number one, just not sending an executed contract.
Okay, hold on.
Yeah.
Pause. Silence around that. Did you catch that? Like, the biggest issue they have is that agents are sending orders with contracts that are not signed, properly executed. Okay, go ahead. Just saying. Just saying.
Properly executed, big plus.
Yeah.
Correct information on the form is also a big, huge issue, believe it or not. So we need actual buyers and seller names. Everybody's a person. There's not a machine that owns anything. So if you're into, like, an LLC, or you have a dead person, so it's an estate of some sort, we need to have indicators of what's going on. So let's say we have two people entitled, their husband and wife, one of them died, and you just put David Smith on there. And so we're going to ask you, where'd Lauren go, if that's his wife's name.
Mm-hmm.
Some people will just put Smith, and then we have to guess who's on it or who executed it. Sometimes we just have random powers of attorney signing things, and it's their name on the contract and not the record owners. So your record owners have to be on the contract, and there has to be at least some reference to where the other record owners are, if they are dead or incapacitated in some way. We're not mind readers. We do certainly spend a lot of time digging and snooping, so we can find out a lot of things about a lot of things. But the more information you tell us, the easier it is for us to get you to closing without us having to dig for that. Some of the other things we see, like Jennifer said, yeah?
Can I ask a quick question?
Sure.
One mistake,
Yes.
okay? So I have one that's not yours, somebody else's, but I'm hoping this attorney gives me more work. Currently, the name of the deceased is Allie Mae Johnson.
Okay.
Okay, but she's not going to sign any contracts.
Right,
Unless she's coming from the dead.
Right.
How do you want that written out? So because he is the attorney, so is it Allie Mae Johnson? And then how do you want the attorney? The attorney is the executrix of this estate.
Sure.
And then the other part of this question could be, maybe next time the executrix or executor is somebody else.
Right.
Yeah.
You know.
Yeah.
And the attorney's obviously just assisting them.
Yeah.
But what information, or how do you want that written out?
Yeah, so how that would go on your agreement of sale is when somebody dies and the estate has been opened, and correct me if I'm speaking incorrectly, but once it's been opened, the property kind of transfers into the entity that is the estate of the deceased.
Okay.
So it would be the estate of Alice L. Smith
Got it.
by the executrix
So and so.
Judy Bloom.
Yeah.
So whoever it is, that's how it would go.
Do you want
Generally,
mailing address, and what mailing address? 'Cause
it would be the mailing address for the executor or executrix or whoever is handling everything. So, the mailing address it is an essential part of the agreement of sale. So generally what we'd like to see there is either current address of that person or their forwarding address, but if they're buying something and they don't really have the forwarding address legally theirs yet, then use their current address.
Okay.
Speaking of forwarding addresses, that is something we also desperately need at the beginning these days. We deal with Jordan Tax Service more and more and more in Allegheny County. That laugh is appropriate for them. So they do require forwarding addresses of sellers before they will release any of the information that we're waiting for with them.
Okay.
They generally still do have at least a 10 business day turn time from the date you order it. So if we ordered something today, we could expect to maybe get it 2 Fridays from now, because we'll add in 2 days for mailing. So really, we're looking at 2.5 weeks to get anything from them. If there is a federal holiday in there or anything like that, then we can pretty much add a week time processing there. So just be aware that as soon as you have that information, please share it with us. We don't share it with any non-affiliated third parties, but Jordan Tax doesn't like to play around. And you can call them, but you can't really speak to anybody. They don't email, they don't fax, they don't do anything other than snail mail. So if you need something from them, we have to have all the information on the first go, or we end up in a delayed situation.
Okay. So we got off on a question, which was a good question. And something I want to point out is just critically important that when you have a listing and you have an entity that is not the purchaser, like you were saying, it could be someone that's deceased, it could be an LLC, it could be whatever. That is one of your initial conversations that you're having with a seller or a buyer even of if they're not taking title in that name or selling in that name, you need to see supplemental documentation, whether it's the will or the estate once it's open and you've got an administrator or an executor or whatever it is. Also, if I'm selling for an LLC or buying with an LLC, I always make sure to send operating agreement to them that shows who are the signatories, if that's the right word, who can sign for that LLC. And you better make sure that that's who's signing. Right. You do not want to have incorrect people on your contract, and you want to be taking that time prior to a contract, even a listing contract, is making sure that you have all of that correct information.
Exactly. Yeah, that's another issue we see is the incorrect person executed the agreement of sale. So if somebody that doesn't have the authority to execute said agreement executes it, you don't have a contract. You have a problem. You don't have a contract though.
Yeah.
So it's very important. On an estate, they're called the letters testamentary and a short certificate. Operating agreements for LLCs, LPs, you can have operating agreements, other kinds of documentation. Corporations, they also have documentation that governs them. Churches get a little funky. If you have a church, let me know. We sometimes have to get kind of creative with a church as far as their documentation goes. A lot of times there's like a board of directors or something of that nature. But if you have one, just let us know. We'll figure it out and get the information we need. A lot of times it's the pastor, but sometimes it's someone else as well.
What happens so I had something like this recently, but it's a seller, so I didn't get to choose whose settlement was. The original buyer was like a person's name, and like 3 weeks later they decided to change it into an LLC. I know that can happen. People decide, especially investors. What do you recommend in that regard? Like, how does that judge things for you?
So in Pennsylvania, you can't really assign a contract. Okay. So if it is the buyer and the new LLC is a sole member LLC, and the principal that was your buyer is now the sole member of that LLC.
And you have the paperwork, is it fine?
And you have all that paperwork, that it should be fine. Worst thing, worst case, do an addendum to say that they agree the title will be transferred into this LLC with this person as the sole member. Now, if you have something where you have like Becky Offit buyer, and then we're gonna change it to be Jennifer Burns LLC,
Yeah.
that can't happen. That is a double transfer tax event. And that's kind of it's a very expensive problem to have. If you end up in that kind of situation, you would need to speak with your broker about that and how to handle it. Basically try to avoid that like the plague. But if it is your buyer who just wants to put it into their own LLC, that's generally not an issue to do that.
Okay, so we've got contracts in terms of things that agents are not completing properly. We've got contracts not being signed fully, the names and forwarding addresses not being on the initial contract. What other things stand out to you?
Yeah, missing parcels. So if you have a property, and this doesn't happen as much like in the city, but it can. It certainly happens a lot more as we get out into what I like to call the fringes. So the other counties, so Allegheny, the further you get from the nuclear city, the more weird things get. So if you have a property that has multiple parcel numbers, I believe your contract pulls through one, or the MLS pulls through one.
MLS pulls through one, and you're only allowed to put it in the MLS with multiple parcels if you can confirm that they're all deeded together.
Got it.
I want to point this out. That is a good point. Is if you try to say, I've got a multi-parcel sale here and they're not deeded together, you can be fined by the MLS. They will contact you right away because they will see that that you have that in your comments because they're checking that. But if you can send them the deed and say, hey, FYI, these are deeded together, they're like, fine, thank you. But if they're not, you have to have them in separate entities in the MLS. So you have to have multiple listings in there.
Yeah.
You are allowed in your public remarks to say this is a multi-parcel sale, for example. Maybe it's a portfolio and not just an adjacent parcel. If that makes sense. I don't want to go down a rabbit hole, but you are allowed to say that in the MLS. This is a portfolio sale. There's multiple properties. Anyway, go ahead.
Is multiple too?
Multiple is more than one.
Okay.
Yeah.
Because I have a situation where I'm trying to get a listing for, where here's the house, but the son also owns the parcel right next to it.
Okay.
You want to see the deed and see if it's deeded together.
Is deeded separate.
Okay, then you have to have 2 listings, and then you will put in both of those listings, they're being sold together, period.
As far as the agreement of sale goes, if you have that situation, so we have two pieces on the MLS, and they're not necessarily even on the same deed, you have to put it on your agreement of sale that both parcels are to be included. So that's regardless if you have 2 parcels, if you have 15 parcels, if you have 25 parcels, they all have to be listed on your agreement of sale as being transferred. So like I said before, we're not mind readers and we follow your agreement of sale. So if you leave one off, the assumption is the other one is not included in your sale. We do generally ask you if they are 2 parcels on the same deed, or 3 parcels on the same deed, or even 4 or 5 on the same deed, and your agreement of sale only has 2, we will ask you about the other 3. However, if you have a situation where you have them on 2 separate deeds and they're both to be conveyed, but you only put 1 on your agreement of sale, only 1 will transfer. So the way title searching is done, we start in the present and move backwards. So we wouldn't necessarily know that your owner owns this parcel and this one if they're on 2 separate deeds. If they're together in the chain, and eventually at some point they probably branch out.
Mm-hmm.
But if they're separate and they've always been separate, we may not know that they also own the piece next door. The other key to that is we don't have access to the MLS. So if you don't send us your MLS sheet, you don't send us the MLS, we don't have a way of knowing that. So that is something to keep in mind as well. So like I said, we're not mind readers, we follow your contract. So you have to make sure that your contract spells out what it is you're selling. Something else to keep in mind is those tax parcel IDs are what title goes by. Addresses change due to 911 services. So occasionally you'll have a property known as 123 Main Street, but through years ago, it was known as 345 Elwood Street. I don't care what the address is necessarily, we do use that to help us confirm what it is we're transferring, but really what we're going by is that tax parcel ID, because in general, those don't change unless there's a subdivision done or a lot consolidation. So yeah, that's one of the main problems we have, especially up north, or if people are chopping up pieces of land. So there's a couple counties that are more offensive than others, like Westmoreland, Armstrong in particular, are terrible as far as they chopped up a bunch of land kind of willy-nilly, didn't follow any real process there. So some pieces have parcel numbers, some pieces don't really have a parcel number. So the moral of the story is know what piece of land you're transferring and get as accurate of a description of it as possible. That doesn't mean to say if you're doing a subdivision or you're buying a piece of a subdivision or something like that, you know, we can certainly help you out with that. We do have experience with that as far as new subdivisions go and lot consolidation. So if you have somebody buying 5 separate parcels and they want to make them all one, we can help you with that too.
Okay, you bring up something here with the parcel IDs. That's one of my pet peeves that I've always had in teaching, is to make sure that the top sheet of the contract, so page 1 of the agreement of sale, is fully completed. So when you think about like the mailing addresses, the forwarding addresses, the parcel ID, I make sure to always put the deed book, the deed page, because you know they're ordering title search, and that's a real person. That's a real person that's down at the courthouse or county, whatever, and they're opening these huge books. If you've never been down there, my licensing instructor gave us, you know, we did a field trip and we went down there and did an abstracted, whatever.
Yeah.
And so you want to just make sure you're filling it out fully. That also includes the agent information, because they're reaching out to both agents to circle all the wagons, herd all the cats, so to speak. And so you want to always make sure that top sheet, don't get lazy because you're busy. I just want to point that out, is to just make sure you're filling it out completely.
Yep. If you do it right the first time and you do it completely the first time, I won't bother you.
Yeah.
But if it's lazy, I mean, I've had people put their own phone numbers wrong, their own email address wrong, like the buyer's agent had the wrong phone number for themselves and the wrong email address for themselves, like, and then we couldn't find them. We couldn't contact them. They're like, we never heard from you. Your contact information's wrong. I don't know how to reach you.
Yeah.
There's another agent that just had the wrong phone number on the internet. So some random dude somewhere else in like North Dakota was getting all this guy's emails and texts.
Oh my gosh.
So make sure your contact information is correct.
So
Yeah.
I had a seller, I have a buyer who sent back the contract, but didn't put down his buyer's information. So I'm, you know, should I harass him about this? I mean, it's
Yeah.
like,
It's a legal contract.
Yeah.
That's part of what I think a lot of people don't quite realize, especially new agents and buyers and sellers, like that
Is a
agreement of
binding.
sale is a binding contract that will hold up in court. And you can and will get sued if you don't follow it. So it's a big deal, even though it's something that's docu-signable and, you know, people just click, done. It's a legally binding agreement. So you have to know what that thing says and what you wrote on it. You know, or didn't, yes. So another pitfall, like we were talking about the applicable addenda, the oil, gas, mineral rights addendum. If you mark it on your agreement of sale but don't include it,
They're gonna ask
we're
for it.
gonna ask you
They're gonna
for
ask
it.
Yeah.
If you still never produce it, the assumption is all rights convey. So if your seller is intending to reserve oil, gas, mineral rights, they have to make that known. And it is your responsibility to make sure I have that addendum. If I don't have the instructions, I can't follow through on them.
That's another pet peeve of mine, and I mentioned it a second ago, is if you mark that, you know, the OGM is included, that is specified par OGM. It is not par OGMD, it's not par OGMX, it's not West Penn, it is par OGM. It is a contract. It specifically mentions that particular addendum. You want to make sure that you're attaching the proper document with your contract.
Yep.
Yeah.
And knowing what it means. I mean, we've actually had some recently, and this was contracts from years ago that weren't as, I don't even know what to say. They weren't as clear as to what we should have. So there were a couple of transactions where the addendum wasn't provided, nobody said anything, and the rights were conveyed, and now we're in messes conveying them back. So can things be fixed? Yes. Are people super mad if you screw it up because you didn't send the paper? Yes. And that's what follows you around.
Yeah.
So make sure you're sending all the right papers. If you're not sure if I need it, go ahead and send it to me. If I don't need it, I throw it away. If I do need it, I'm happy to have it. So it doesn't hurt me if you share all
Everything.
kinds of stuff with me.
Yeah.
Something else to keep in mind if you're dealing with investment properties and you have tenant occupied, first of all, you should have that tenant occupied addendum.
Page 2 of your contract.
You should also send copies of leases and security deposits and rents to be prorated and what we're to do with that. I can't tell you how many times we've had an investment property transferred. Nobody says anything until they're at the closing table, that they've got 10 security deposits and a bunch of rent to prorate. And
Oh my
they didn't
gosh.
bother to tell anybody about it. They got the settlement statement a week ahead. Nobody looked at it. So if you have something like that, let us know. Make sure we know about it.
That's such a good point. And I was talking to a newly licensed agent yesterday, and we were talking about, you know, their interest in maybe working in commercial. And I was just saying, you know, get your feet wet in residential, get familiar with the contracts and just kind of what I call the flow of things, and working with people. Also, you know, as newer agents that are learning, don't just take a listing for a multi-unit without talking to someone here at the office. If you've never done one, don't just take a commercial listing without talking to someone here if you've never done one. We're going to partner you up with somebody that's done a deal like that, or just make sure you're dealing with a PC coach or a TC coach. Again, just to, the goal here is to always serve the public the best of our ability. And just because you want that experience doesn't mean that you can just go it alone. So just always make sure you're talking with somebody.
Yeah. And
Okay.
commercial is the wild, wild west too. So keep that in mind as well.
Yeah.
If you're a little less experienced of a residential agent and you go into your first commercial transaction, they're going to kick your butt, and eat you alive. So get help with those because they're not your typical transaction. They happen differently. Timelines are kind of out the window. Things are more suggestions than rules. And you know, you really want to work with somebody who can help you through that, get coaching through that. There is no shame in asking for coaching through that. So you can certainly reach out to Jennifer, you can reach out to me, you can reach out to Joe. McGavis is your brother, right? You can reach out to Mike McGavis if you can reach him. But you know, you need to have somebody help you through those because that's how you learn, but that's also how you stay out of trouble.
Yes.
So
We want you to keep your license.
we want you to keep your license. That's all of our goals, really. So one of the things I always say about us in title is we're here to help you. We're also not going to let you get in trouble on our watch. So if you're trying to do something shaky, shady, sneaky, I'm not going to let you do that.
Yeah.
So you might not like me because of that, but I will keep you out of trouble. So just keep that in mind too. You want to work with people that you know, like, and trust. And you want to work with somebody that's got your back. And I've got everybody's back in the transaction because I like my license too.
Yes. I thought of something. Do you have anything else to add that would be, okay. So something that's, I think, really important is to, when you open a file with settlement, they immediately will order the title search. That is funds that this company is paying to a real person that's beginning that process. If you are the buyer's agent or, and you get through an inspection and you know right away that you're going to terminate, or this doesn't look right, or something's looking like it's going south, the first person you're calling or emailing is settlement to make sure that they can maybe put a hold on that title search for a minute, because they're out that money if it terminates.
Right.
So we want to protect our allied resources. I just want to make sure, like, you're communicating those things to the lender and to settlement, because there may be an appraisals being ordered through the lender. Obviously they're doing title search. So does everybody understand what I'm saying in that regard, that you're communicating with them if this deal looks like it's going south? Does that make sense? We want to protect one another. Okay, so tell us a little bit about, and I know that there's something in the handout there. So we will scan these over to you guys that are attending online, but she wants to talk to us a little bit of one of the things that you're going to find your clients will ask about is how to take title. So talk about those descriptions.
Yeah, so how to take title is a fun conversation to have. So I'm going to preface this with, I am not an attorney. So if you have somebody that has questions on how they should take title, your reference is always, I am not an attorney. Here's the number of an attorney you can call unless you have a family attorney who can legally advise you. That being said, taking title is a legal choice on what they're doing. So your options for you there are, and just so everybody understands, taking title means how you go on the deed. So there's a couple options for you. If you're an individual, it doesn't matter because you're an individual. If you're an LLC, corporation, something like that, also doesn't matter. The ways to take title really only apply to individuals in multiple. So there's 3 options for you in Pennsylvania, under Pennsylvania law, that you can choose as far as title goes. The first option is tenants in common. That is what is automatically assumed if nothing else is specified. Tenants in common means that, God forbid, one person on title were to die, their ownership interest passes to their heirs. Their heirs may be their children, their parents, anyone who survives them, not necessarily the other person unless there is that familiar relationship already existing. A lot of times we're talking about people that are, buying a house in contemplation of marriage. So they're not married yet, or maybe they're just friends, they're not even engaged, and then we ask them that question, cart before the horse. But anyway, if they're not a married couple, they're just 2 people buying a house together, automatically assume tenants in common. You die, your ownership interest passes to your heirs, not the other person. How that can look when somebody does die in that situation, let's say Jennifer and I buy a house together as tenants in common. I die. Jennifer now owns the property with my husband and my minor children. So technically just my husband, but if my children were adults, she would own it with my husband and my children. You can do a couple things with tenancy in common. You can hold unequal shares. So let's say I would own 60%, she would own the other 40%. I could own 10%, she could own 90%, that's fine. The second option for unmarried people is joint tenants with right of survivorship. What that means is, once again, somebody has to die for it to matter. Let's say, once again, Jennifer and I own the property, I die, we hold as tenants with right of survivorship. My share would pass to her under the law. Now, since we're not married, she would have to pay inheritance tax, and any of my creditors' judgments would stick to the property and become her fund debt. Luckily, I don't have any, but you could.
Yeah.
So, kind of a couple differences there. Joint tenants with right of survivorship, you must hold equal shares. So the 2 of us would hold 50-50. If there were 4 of us, we would each have 25%. It's a little tricky whenever we have a married couple and an extra person in there. Married people are treated as one under the law. So if we have husband and wife, husband and husband, whatever they are, they're married to each other, they count as one person. So if we have Becky Offit, Bob Offit, and Jennifer Burns in title, Becky and Bob Offit own 50%, Jennifer owns 50%, even though there's 3 people. So that can get a little tricky with some people. A lot of times you see that case when it's parents buying property with their children or their child.
That's the only time I've seen it. Like, that's the only way I've seen it.
Yeah, that's generally the only time you're gonna see that. We've had a couple of people with like siblings and spouses and everybody, holding with their spouse and then their spouse, and then they have to decide how the two couple entities are gonna hold together. The heirs of said person don't come into play when it is joint tenants with right of survivorship, but inheritance tax does apply. Third option is reserved for married couples. So anybody that is legally married in the state of Pennsylvania is considered a married couple, and they can hold as tenants by the entirety. That is only for married people. What that means is, once again, you are an indivisible unit, so you would own your portion 100% between the two of you. One of you dies, it doesn't matter, that person still retains that full ownership because you are a unit until the final tenant in the entirety passes. There is protection there for creditors' judgments. Certain liens cannot be filed against marital property. So credit card judgments can't come back to bite you. Criminal judgments can't come back to bite you. So if you got somebody that's going out and getting DUIs, killing people, that kind of thing, doesn't attach to the property. So they can't take it away from the surviving spouse of said criminal. Inheritance tax generally does not apply when it's between spouses. So it is important to note that whatever is on the deed is what stays in place forever. So until you change it or somebody dies. So let's say you do take title, or your buyers take title before they get married, they decide they want to do tenants in common because maybe somebody's mom and dad gifted them money, mom and dad want that money back if their kid dies, something of that nature. I mean, forgive me for being flip, this is just how it kind of, how you talk about it. I mean, we could fluff it up with fancy words, but reality, their kid dies, which sucks.
Yeah.
But if that happens, then, you know, tenants in common, then it's your buyer and their dead significant other's parents entitled. When they do get married, it doesn't automatically change to tenants in the entirety. So they have to actually change the way they hold title on that deed. They have to have a new deed drawn up to create that tenancy by the entirety. Some lawyers and judges will kind of see that that was what was intended. So if, let's say, a husband and wife did take title and they didn't specify husband and wife or tenancy by the entireties, but they have the same name, they were married when they took title, usually an attorney can argue that case and win. But best practice is to kind of know up front, have it specified on there so you don't have problems down the road. We did have a couple that went into title as tenants in common, and then he did pass away like the next year. I think he literally got like hit by a bus. So they weren't expecting it, they weren't married yet, but she ended up in a weird title situation with that. So it's a conversation to have. It's kind of an uncomfortable conversation to have because you're talking about a future event of, hey, eventually we're all gonna die. What do you want to happen to the property when you do die? Sometimes wills can supersede things. Wills can muck things up or clarify some things. So if they do have a will that names the other person as an heir, that kind of thing. But basically, don't get into all that. They have 3 choices. I have a handy dandy sheet for
I'll
you
send that to you. Yeah.
that Jennifer will send out, and then we talk about it at the table if they have questions. But my go-to is always, if you're not sure, call an attorney. We can wait.
Yeah.
So
I've got a question
Yeah.
because I think having real world examples is always
Mhm.
good. So, and I've talked about this before in class and you know about this. So I had a sellers that were divorced and the husband remained in the marital home and she moved out of state. They finally got to the point where they were ready to sell. And the day before closing, this was before title search was added to the contract to be done within a certain amount of time. The day before closing, we got word, and I didn't get to select the settlement company, but we got word that there was a $20,000 credit card bill on settlement to get paid. And there was just a lot of hoo-ha about that because it was a credit card bill. I guess he had some girlfriends during his marriage. And so I remember calling her and going like, how does this happen? And I didn't think that you could put that. And all of a sudden, when you're explaining the way that they took title is most likely tenants in common, because if you were saying judgments and stuff like that can happen in that type of taking title. If they had done tenants by the entirety, is it possible that that credit card judgment would not have been leaned against the house? That's a whole ball of wax, isn't it?
well, the problem is they got divorced. So if you take title as tenants by the entireties and then you get divorced, your tenancy by entireties is severed. So you lose it then because we work forward to backwards. So we have our tenancy by the entireties. Let's say we have a couple refinances, we have our divorce. Divorce severs that tenancy by entireties. Any of those liens are now like, hey, we're gonna get paid,
Wow.
and they get attached to the property. So it gets pretty tricky with that. The moral of the story is if you get divorced, I'm not an attorney, so you didn't hear this from me, get your spouse off your deed.
Yeah.
Get them off as part of your divorce. You don't
Well,
let them stay on there.
Yeah, and that's just a huge thing to keep in mind. If you're sitting at a listing appointment and one of the sellers is not there, but the other seller mentions that they're in the middle of a divorce, I would immediately call a resource like Becky and say, okay, what other things should I be asking here? Because I want to make sure, because we're supposed to do net sheets and all that other stuff, like you want to make sure that you are representing them well, so you don't get the crying wife on the phone the day before closing that she's less 20 grand in her proceeds because of this ridiculous lien that was on the house that she didn't know about.
Yep.
So, okay. All right. The last question that I have is, tell us a little bit about title insurance. I've been seeing this a lot more lately. You guys are providing a really great sheet that explains what the difference is between a standard title insurance as well as an enhanced policy, and the difference between an owner's policy and the lender's policy.
Okay, that's a lot.
That's a lot.
All right, so title insurance itself is different than any other type of insurance that you have. So most of your other insurance policies cover you from events that are going to happen in the future. So your homeowner's insurance, they technically call that hazard insurance, is what's required. That's if your house is catastrophically damaged in some kind of situation. So it burns to the ground, the roof falls because of hail, something like that. But that's something that happens in the future. Car insurance protects you from future car crashes. Now they assess it based on your risk. So if you've wrecked a bunch of cars, you get a bunch of speeding tickets, your policy's higher, that kind of thing. But they're mitigating future risk. Title insurance is protecting you from the past. So title search, once again, we start here, we move backwards. We check the public records back 60 years is the time frame of the search. There's not really any magic to that. That's just what everybody decided was good enough. As far as how long liens and those kind of things last. Some liens are indefinite, they last forever, but in general, after 60 years, anybody that would have cared to collect is now dead. So we don't care so much about that. But the title policies cover you for things that come up in the future that were missed on the title search in the past. So things that are covered under that would be prior owner mortgages, inheritance tax, liens, tax liens, municipal claims, divorced people's creditor judgments, messed up tax sales, foreclosure issues, those kind of things. They also cover you for fraud, forgery, impersonation,
Contractor liens, that.
contractor liens. Yeah, contractor liens are actually an exception.
Okay.
But yes,
Yeah.
yeah, they do get searched. So if there is a situation, there's an item on the owner's affidavit that states that there hasn't been any contractor work done in the last 6 months who's not been paid in full. So it is still an exception to the policy. However, you can sue your seller if they lied on that affidavit. If there is a contractor involved, they would sign a mechanics lien waiver, that kind of thing, but that's a different discussion.
Yeah.
So as far as the policies go, the lender's policy covers the lender for any financial loss that they suffer due to their lack of first lien position. For a lender to make a claim on a loan policy, they have to actively be foreclosing and unable to do so because of their lack of lien priority. What does that mean to you? So I don't know how much, do you guys learn about lien priority a lot? No? Okay. So when you buy a house and you get a mortgage, your lender is asking for title insurance to say, there are no liens against this property that will take priority over your mortgage. What does that mean? So mortgage is obviously a lien. There are other liens that can discharge a mortgage. So child support can discharge a mortgage, federal tax liens can discharge a mortgage, a municipal lien or a tax lien can discharge a mortgage. The lenders feel so passionately about these policies because, let's say you buy something in the city of Pittsburgh for, I don't know, you buy it after a flip. So let's say somebody flips a property, they bought it for 10 grand, they flip it, they sell it to you for 200,000. You get a mortgage, everything's good and fine. You then find out that seller never paid off the $5,000 tax lien. The tax lien, because it existed before your mortgage, took priority because it was first. It's also super lien, so tax liens do supersede mortgages in certain cases. So we've got our tax lien filed here, we've got our mortgage filed here. Tax collector says, hey, I need to pay this $5 grand, I'm gonna take this to tax sale. They do so. They win. Your mortgage, too bad, so sad. Unless there's a little bit of money for leftover. So if the tax gets paid, then any additional amount would get paid to the mortgage holder. But your lien holder can get discharged by a tax lien or something of that nature. So that's why they want us to say, that's not going to happen to you, and if it does, we're going to pay for it. That's what the loan policy does. In essence, there's a couple other quirks to it, but that's the main reason they want it. Now, like I said, the lender has to be in a position where they are actively foreclosing to make a claim, and they still feel that passionately about having the policy. So that should tell you something about the importance of it for an owner. The owner's policy covers the owner of the property so that there would not be any claim that could challenge their rights to the property. Something that could come back. The most common title insurance claim are home equity lines of credit that don't get closed. So let's say your buyer buys a house, the seller had 2 mortgages. They have their main $200,000 mortgage. They also have a $50,000 line of credit. They don't say anything about the line of credit. It's misindexed in the public record. Nobody knows about it. They don't say anything. They keep it open. They continue to draw on it. So they run up a $50,000 credit line. Maybe they increase the line. They then charge it up to $300,000. And your buyer goes to sell the property or refinance it. They find out there's a $300,000 or a $300,000 debt against the property that's now theirs. That is a title claim. That particular situation would likely be a full reversion of title, and it would pay off the full claim of the policy. The policy limit is the purchase price generally. The enhanced policy does appreciate in value, so I do believe it goes up by 10% in value over the time of the policy. So you could get covered for additional, equity in the property. But in essence, the owner's policy covers you for anything that the prior owner did that comes back to bite you down the road. So those home equity lines of credit are huge. That's why we're such pains in the butt about them. So, we make the seller provide us information. We do the public search to make sure there's not another mortgage there. And then we follow up on it like crazy to get them closed and satisfy the record so they go away. So those are the number one title claim. Other things that protect you from tax liens, all that fun stuff we talked about. The standard policy is what we reverted to for a long time. There were other companies that typically issued the enhanced policy right out the gate. You had to opt out of it. We've started learning more about the enhanced policy and actually found that it does offer a lot of good coverage. It does cost 10% more than the standard policy. So title insurance policies are regulated in Pennsylvania by the Title Insurance Rating Bureau of Pennsylvania. Also, fun name. And I mention that because there are a couple of entities out and about in the county that will offer a discounted title insurance policy. Certainly they can do that, but you get what you pay for. So with anything, if you're going out to get your homeowner's insurance and you really like your house, you put a lot of money into that house, you're going to go with an insurance provider that has the money to pay for the claim if you have an issue. You're not going to go with cut rate insurance that doesn't have any reserves to pay for a claim, because there's more point in
Right.
having the insurance then. I mean, it's cheap, you have it, but it doesn't actually do anything if you have to make a claim.
Mm.
All of the title insurance agencies, myself included, that subscribe to Tier BOP are regulated. So the title insurance fee is the title insurance fee across the board for all of us that subscribe to the Title Insurance Rating Bureau. That keeps us all competitive, keeps us all regulated, keeps us from charging you and your clients any junk fees. So that's what you want. But basically, there is a rate chart on our website under our title fees. I will send you that as well. And there's a link to our website in there that you can find. And it has the actual chart. So in Pennsylvania, the title insurance rate is based on the sale price or loan amount, whichever is higher, and then it is a simultaneous issue. So for one premium, your buyer gets the loan policy and the owner's policy. Now, on the closing disclosure, you're going to see them as the lender's policy will be up in section C, I believe, might be in section B, I think it's in section C. And then the owner's policy will be in section H, which shows that it is optional. It is only optional because in other states, it is not a simultaneous issue, and it is normal and customary for the seller to pay for the owner's policy. In Pennsylvania, especially in this Western PA market, the buyer pays the policy, and that's why they get to choose the company. They get to choose the closing company, so it's always the buyer's choice. You can certainly suggest whatever company you're comfortable working with. I certainly hope it's me, but you know, they get to choose that policy. So if you have a contract where the seller says you have to use the seller's closing company, that is not true. It's up to you if you want to battle that.
Isn't it true, or my understanding of like a different weirder version is that the lender's policy also decreases as the loan value
It
decreases?
does, yes.
So that coverage changes as you're paying off that loan. So for people that waive title insurance from just even the standard side, keep in mind that that coverage just reduces over time. And then the standard policy, again, is the purchase price, and the enhanced, you know, can appreciate in value in terms of like the way that your investment is appreciating in value. So I just often, if anybody has questions about title insurance, I always send them. Again, my licensing instructor just said, be the source of the source. Just get them to a professional that can talk them through what those values are. Does anybody in class here have any questions? Yeah.
Quick question. Not that I think this would be a smart decision, but if I have a cash buyer, we understand completely the bank, if it's a mortgage property, is going to guarantee they're going to get paid from title. I have a cash buyer, and they're starting to scream, oh, all this money. Can they opt out of title insurance? I know it's a stupid thing to do,
They
but
can.
there's stupid people out there.
Sure. Oh yeah, there's super stupid people out there. So you can waive owner's coverage on a cash transaction. You can waive owner's coverage if you're getting a loan. The owner's policy only covers the owner. So the lender's policy does decrease in value, but that policy only covers your lender. So if your lender gets a policy and you waive the owner's coverage, you have no protection. You're naked in the world with your property and all of its blemishes. On a cash transaction, can they waive it? Yes, they can. The caveat there is then they have to have an attorney handle their transaction, because my company is a licensed title insurance agency. So if I am not issuing a title policy involved in that transaction, I cannot touch it because it would be practicing law without a license to do so. My licensure does permit me to prepare deeds. I can prepare other documents and all of that as long as I'm issuing a policy for that transaction. I am covered under that bucket, but I can't write a deed if I'm not insured.
And again,
Yeah.
it's not a smart thing to do,
No.
but we've all seen people who.
Yeah.
Well, and if you've got a cash buyer right out of the gate, they're showing you their cash, that's an upfront conversation to be having, like, are you prepared and are you ready? And understand the needs for owner's title insurance. And if they say, yeah, that's not an expense I want, then now you're having a whole other different conversation.
Right.
When you choose a property and you go under contract, you then have to make sure you're dealing with a real estate attorney. Okay.
And just for, you know, ballpark figures here. So The title insurance rates are generally, your average home, you're looking about $2,000 or $3,000 for the policy. To get an attorney to talk to you for as many hours as it takes to do any research, then conduct a closing, transfer money, issue with all that stuff.
You're paying
You're
for it.
probably paying for it anyway, but
Yeah.
not getting anything for it.
Yeah, you just get the transaction and it closes.
You get the
and
transaction
it.
and that's all you have.
Mhm.
Do attorneys have some kind of tail coverage if they die? Sure. Your owner's policy of title insurance would cover you for as long as you own the property or as long as your buyer owns the property. So that policy lives until you sell that property. It will sometimes even extend to the heirs of the property. So like if my kids inherited my property, my policy would also cover that.
Wow.
One of the main things that's really cool about the owner's policy is that it does cover attorney's fees if you need to defend your title in court.
Wow.
So if some claim were to come up that you had to go and battle somebody in court over your right to own this property, let's say somebody didn't get good service in a tax sale. That owner comes forward, they try to sue you because they lost the property, they weren't notified. You get a free attorney to go fight for you. And they're not necessarily free. They're paid by the title insurer and they're gonna win as best they can because they want to.
Yeah,
They
that's
don't
their
want to
client.
pay the claim.
Yeah.
And you're their client. So you get the underwriting attorneys that go out, well, it's not underwriting, it's claims attorneys that go out and they battle, and they are scary people. They're nice enough, but they're a little scary. And they're very serious about what they do. So if you need them, certainly nobody wants to go battle Fidelity, National Title Insurance Companies, underwriting people, or First American, and that's who we write through. We write through the two largest underwriting insurance companies in the country. So we have both of them that back us as far as the policies go. Yeah, and that's not to say there weren't claims. I mean, we had that situation that I described before with the HELOC that was 50 grand that nobody told us about, that was misindexed. The guy took it out without his wife's knowledge. He didn't have his middle initial on it. It wasn't found by the searcher. Fidelity paid out a $50,000 claim for those people right out the gate. It was like 2 weeks after they bought the property, the foreclosure process started on that HELOC.
Wow.
So it does pay, and that was no fault of anybody that was doing their job.
Yeah.
It was just the guy, the way it all fell, it wasn't found, he lied about it, and pretty sure they then sued him, but
Yeah, I was
as
gonna
far as
say,
it goes for
they
the
pay out and then
buyer,
they go after the culprit.
they pay out and then they go after the culprit.
Okay.
So they do make their people whole and they hold up to it. So,
Okay.
yeah.
Lisa, Josh, do you have any questions?
No, I don't have any questions.
Okay, Lisa, any questions?
Nope, I'm good. Thanks.
Okay, fantastic. Well, I just want to say thanks for you guys coming. Really appreciate y'all always popping in. Thank you, big thank you to my friend Becky here. We're gonna send you some information and her contact information out of me. They're also like one of our preferred vendors. They're gonna be officing out of our new building as well. So if you ever have any questions, she's a great resource. But thanks, everybody.
Yeah,
Appreciate
thank
y'all
you.
coming. Have a good week.